Declaring personal data as property. Too long, didn't read version. The problem. In this internet age, data about individuals can be copied around the world and used without the knowledge of the subject for purposes productive or malicious. A problem the framers could never have foreseen. We have this new capability to collect, use and distribute personal data, but we have not had the time to develop the social rules and laws that ensure this new capability is not used in harmful ways. How can we change the digital rights landscape to restore privacy and security to individuals? The proposal part A. Declare data about a person to be their property, and therefore any collection, storage, transmission or use of such data, outside of a fair use provision, would require an explicit license from the individual. The proposal part B. Culturally adopt the view that personal data is exactly that, personal. It is not simply a commodity to be mined, processed and sold. Disclaimer. I am not a legal expert. This is just an idea I wish to explore and one I strongly believe will help greatly to remedy many of the social ills resulting from social media and the digital age. Any feedback on the ideas expressed would be appreciated. If there is any part of this that is not clear, please feel free to provide constructive feedback so I can improve my explanation. Assumptions. Due to the majority of digital services being US-based, this proposal will need to be enacted in the US first. As the US is the only country where the little people have any real chance of enacting a change like this, I have tailored the proposal to the US despite being in the UK. This legal change, in conjunction with changes to Section 230 of the Communications Decency Act, will restore control to the correct place, the individual. The cultural value behind the proposal. The rise of the computer age has led to a problem the founding fathers could never have foreseen. In the era when the Bill of Rights was written, information about an individual took significant effort to collect. In the modern world, data about the lives of hundreds of millions of people can be copied and distributed around the world in seconds. The problem goes deeper than a legal question. We need to revisit our perspective on what personal data is, in the existential sense. Data about us are not merely a collection of numbers or words devoid of any deeper meaning. They are a reflection of us as individuals. In a very real sense, they are part of us. We need to adopt the cultural value that personal data is exactly that, personal. It is not something that anyone other than those with whom we have agreed to share it should have access to. If I do not wish to share my address with the world, that is my right. If I have not specifically granted a person or company a license to use my name and address, they should not have access to it or be able to use it. What is the proposal? Declare personal data the property of the individual, giving the individual similar control to the author of a copyrighted work. Any use of that personal data outside of fair use will require an explicit license from the individual, what I will refer to as a User Data Use License, UDL. What data are we talking about? Any data that is associated to any individual, whoever has created it. This will need to be enacted through federal legislative process, ideally with a constitutional amendment. It will also require test cases to go through the courts to cement the fair use provisions, such as in the public interest journalism. I suggest accidental collection and or storage of data outside of the UDL will be a civil offence. Deliberate illicit collection, use or distribution of data will be criminal. The legislation, one of two. While it would be good to take advantage of this legislation to collect together all IP-related laws into a unified whole, there are many vested interests, so I will limit this to the specific items that will need to be accommodated in the legislation. The bill should include data associated with a person in a form that is easily accessed, searched, copied, or transmitted is their property. Accidental data collection or storage without permission is a civil offence. Deliberate data collection, transmission, use or storage without permission is a criminal offence. The state is only exempted for data essential to administrative tasks such as taxation and the justice system. Any person or organisation with data about a person will be subject to civil or criminal penalty unless they have a licence agreement with the individual. The legislation, 2 of 2. Transfer of any data outside of the jurisdiction of the US federal government will be a criminal offence unless explicit permission is granted. Backup storage of data previously covered by a user data use license will remain covered even after the license is ended, providing the data is not accessible outside of a backup restoration functionality. The holder of such backup data must keep the data secure and destroy it when reasonably convenient. Fair use covers of significant public interest information, such as the names and photos of suspects at large, incidental collection of data, such as an individual being in the background of a picture taken in public, providing they are not the subject, friends and family use of data, such as names and addresses and birthdays, providing there has been no recorded request to remove the data, public discussion of those who have chosen to be public figures, their declared public works, and any topics of significant public interest. Personal data abuse examples. I'm now going to go through a set of examples where personal data is abused under the current system. Example: collection of personal data. Social media has allowed us to share our lives with friends, family, and the world. But social media companies, search engines, email hosts, supermarkets, and many others have been collecting data without our knowledge or permission. If data is our property, any collection of data must be without explicit permission. When we sign up on a site, as part of the process, we will need to provide the company with permission, what I will refer to as a UDL, User Data Use License, to collect and use our data for the intended purpose of the site. Data will still be collected, but as we have granted a license to collect our data, we will know what they intend to collect and give positive assent to that collection. If it later turns out that the additional data was collected outside of the terms of the UDL, the company will be civilly or criminally liable, depending on whether the collection was accidental or deliberate. Example: distribution of personal data. Social media allows us to share aspects of our lives. This requires that others are able to access some of the data we have chosen to share with the social media company. The UDL defines what can be shared and how it is shared. Sharing of social media data outside of the terms of the UDL will be a crime. So, selling private data to advertisers, unless agreed to in the UDL, will be a crime. The same logic applies to supermarket store cards, bank records, or any of the data collected about us. We own the data, and any distribution outside of that to which we have explicitly agreed will be a crime. Example: use of personal data. The data we have agreed to the collection of will be used in many beneficial ways, from something as simple as using the music choices we make to refine the tracks offered to us by services such as YouTube, to something as deeply personal as our medical records or scan results being processed to determine whether we have any medical conditions that require treatment. The uses to which our data can be put must be explicitly defined in the UDL. If I agree to a website refining what content it offers me based on my prior use, it does not follow that I have to allow that data to be used to predict my political leanings, with re-education content offered to me if the people who run the company do not like my politics. The uses to which our data will be put will need to be explicit, with protected classifications being defined. Udal example. May we use your data for site moderation based on political viewpoint? Example. Doxing. One issue of significant concern is doxing, the public release of personal details such as name and address. This is often done with the expectation that others will use that information to enact extrajudicial punishments for conduct the doxer does not support. If your data is your property, the site with your data has no authorization to share said data with the doxer. The receipt of the information by the doxer is a criminal offence, as they have no fair use claim to it. The release of that data is then an even more serious crime, and anyone who receives the data becomes criminally liable. A simple case. A person moves home to get away from an abusive ex, who they have clearly told they wish to have no contact with. Why does that ex have the right to their victim's new address? There is no justification for them to have that address, unless she has visitation rights to children. Therefore, releasing that new address to the abusive ex becomes a civil and criminal offence, and the ex's possession and use of said address is also a civil and criminal offence. Example. Employment attacks. One of the more despicable tactics of the left is coercion into silence by threats of, or actually contacting, a political opponent's employer in order to get them fired and thereby destroy their life. It not only highlights the depths of evil the left has fallen to, but it is having a tyrannical effect on the population, who now feel they simply cannot risk expressing themselves for fear that the fascist left will find their employer, or their bank, family members, etc., and through false claims get you fired or your accounts closed. If I post an opinion under a pseudonym or even my real name, it does not give anyone moral or legal permission to find other details about me. If I have committed a crime, the correct course of action is to raise the issue through the legal system, and it is up to the state, with its due process limits, to determine how to proceed. Obtaining data about a person would be a civil offence. Using that data without a compelling fair use argument would be criminal. Example. We're gonna find you. Threat of personal attacks facilitated by personal data to suppress free speech. One of the new avenues for the left to be authoritarian and evil, destroying the lives and rights of those who do not submit to their every whim, is using their apparent access to personal data to threaten reprisals or actually turn up at people's door to protest or even attack. What are the correct routes to protest the speech or actions of another? If their behaviour is a crime, call the police. If it is against the website terms of service, report the user. If it is the idea behind their post that is the issue, contact your legislator to discuss making it illegal. Start a campaign group or run for public office yourself. What not to do? Turn up at their home in order to intimidate them into silence. It is therefore not reasonable to expect to have access to another's home address. Example. Biometrics. Use of our biometric data against our wishes, for example facial recognition, being used to track us or identify us without our permission. There cannot be anything that is much more us than our biometric data. Why should any person, business or the state, have any access to any of this information outside of that which we have agreed to, or that which is essential to law and order? And even then, they should only possess it if they have probable cause to suspect illegalities. If we choose to get a driving license, then we can agree to a photo being taken, or information such as a general description, height, weight, eye color, etc. This wouldn't stop the use of video surveillance, but any identification of an individual on that video would need to be justified as they are a suspect or a witness. Additionally, without a conviction, the retention and use of that personal data, video, image, name and address, must be limited in scope to that specific criminal investigation and others for which there is good reason for suspicion. Example: provoked fake hate crimes. Provoked fake hate crimes. Harassing a person, then recording them being defensive and releasing it to the internet with claims of their racist motivation. We have now seen the rise of a particularly disgusting tactic used by those who seek notoriety. Provoke an individual, then video the aftermath, selectively edit the video, and display the out-of-context clip to the world. This has life-destroying consequences for the victims. While videoing in public, where recording of other people is incidental and therefore no problem, once you make another person the subject of the video, you cannot then distribute the video without their permission, or without making them unidentifiable. Setting the mob on someone you have framed by videoing them after you have provoked them is a disgusting tactic and must be stopped. It destroys lives. Example: use of unapproved data. Businesses using speech or non-criminal conduct that did not happen on their platform as justification for banning users. If we agree to use a website or other business that holds our data, it is not reasonable for that business to then use data from other services to which we have not agreed. If I have an agreement with website X, if I have not given them a license to use data about me from website Y, if they do so, it will be a civil or criminal offence. How will normal activities change? Examples: banking, retention of records and credit ratings, online shopping, accessing family member wish lists, driving licenses, how the state can use your data, employers, holding data about individuals, fair use. Example: banking. If I want a bank account, I will have to grant the bank a license to store and use my data, and the bank may require that I have had an agreement with a credit reference agency for a certain number of years, and to open the account, I have to agree to that. Banking will work in much the same way as it does now, the difference being the data stored by the bank, how it is used, and with whom it is shared will become transparent, and we will have agreed to it. If subsequently the bank wants to earn money by selling our data to China, for example, they will need an update to the UDL they hold from us, or that sale will be a criminal offence. Example: online shopping. One of the wonders of the modern world is the advent of the wish list, so we can get our friends and family the gifts they actually want. We can have two ways of this working in future, much as it works now, with a UDL that says the online store can display our wish list publicly. This, in addition with the fair use provision we hold to use our friends and family names and addresses, we can select a gift and send it to a designated address. Alternatively, the online store can facilitate our agreement that another person can access our wish list and even our preferred delivery address. If I give my username to a family member, that family member can add my username to the permitted users who can access their wish list. As stated previously, little will change functionally with the data as property law. The difference is that we will have control of our data, and if our data is abused, we will have legal remedies. Example: driving licenses. State optional services such as driving licenses. For items such as state licenses, we are required to agree that the state can hold certain data about us: name, birthday, address, photo, etc. The data we are required to agree to allow to be collected and used should be only that which is required for the administration of that service. Administration of a driving license does not require us to hand over our internet user IDs, for example. Example: employers. Employment is a mutually beneficial arrangement, the terms of which are agreed to by both parties. As with any agreement, the employer and employee can agree to any terms, with the difference that, as data is the individual's property, the data collected and stored must be explicitly agreed to. Any business is free to insist on an NDA from their employee and must respect the data they have on the employee. And while the employee may be publicly associated with the company has no right to use private information outside of that agreed to in the UDL. Example: fair use. Fair use: the use of private data outside of a UDL, deemed to be acceptable as it is, minimally intrusive and has assumed consent, required for dealing with issues of law and order, such as holding details of parties in a civil suit or processing an insurance claim after a road traffic accident. There will need to be test cases through the courts to establish the full scope of fair use in the context of personal data. And finally, many thanks if you made it this far. I would like to make a request of you. If you like the idea, please contact your elected representatives and raise it with them, either in your own words or a link to this video.